Good afternoon, everyone, and welcome to today's webinar, The Legalities of an Employment Contract. My name is Karen Labello. I'm Director of Education for the New York Chapter ACP. Our facilitator today is Attorney Lori Cohen. Lori represents healthcare clients in corporate, transactional, and regulatory matters and provides counsel on a wide range of healthcare operational and compliance matters. Before we begin, I'd like to review a couple guidelines. All participants will be on mute since we have such a large audience. If you have a question, please type it in the dialog box on the right, and Lori will answer all your questions at the end as they come in. If we run over the allotted time, we will send the answers to your questions through email. Following the webinar, you'll receive an email with a handout to the presentation. We will also have a recorded version of today's webinar posted shortly on the Early Career Physicians webpage on the NYACP website. I would now like to welcome our attorney, Lori Cohen.
Good afternoon, everyone. So I'm going to run through the elements or common provisions in an employment agreement. And prior to the presentation, we did receive some questions around various aspects of employment agreements that some of you actually may already be parties to and signed, and others of you in the audience may be considering or anticipating your first employment agreement. So hopefully we'll be able to address all of those questions in this presentation. And as Karen said, if not, please feel free to insert your questions and we will address them at the end. So when considering an employment opportunity, oftentimes, especially if it's your first position, you're thinking more about, how do you present yourself in the best light to be considered by a prospective employer. I would recommend that as professionals, you as well want to consider, what do you know about the employer? What are your expectations from the employer? And, that you really want to consider that you're interviewing them as much as they may be interviewing you. And in that regard, I strongly recommend that you do some due diligence. And so as we go through this presentation, I think you'll want to consider what you know about the employer, what you know about others who have accepted employment with them, whether they have been happy with their decision. You may also want to ask questions of whoever's interviewing you about, how frequently someone might be leaving employee, what the experience is in terms of how they retain their staff. So as part of that due diligence as well, you want to have conversations about what's going to be expected of you. Where will you need to maintain hospital privileges? What are the expectations around health plan credentialing, and what assistance will you receive from your employer in completing, whether it's your privilege applications or your credentialing applications with managed care plans. We're going to talk about compensation. We'll talk about malpractice insurance and understanding the difference between claims-made or occurrence policies and why a tail policy may be important depending upon how your insurance is written. We'll talk about term and termination and covenants not to compete as well as issues around medical records. So in New York, if your plan is to, following training, to stay in New York, I would say that overall the job market in New York continues to be very strong. In the State University Center for Workforce Studies, it regularly surveys and assesses the workforce in New York, and the demand for primary care physicians remains stronger than demand for non-primary care physicians. But there's demand across the board throughout New York, especially upstate and western New York. So what is an employment agreement and what isn't it? So the employment agreement, as some of you already know, it defines the relationship between you and your employer. It's going to set out the rights and responsibilities of each party, and it's typically the controlling document that everyone turns to if a dispute arises. It's important to recognize that most people never have an employment agreement. It's not the norm. The default is what we call at-will employment, and generally an employer as well as an employee in an at-will employment arrangement can terminate the employment at any time for any reason, with or without notice and with or without cause. So when you think about your employment arrangement, you should recognize that it is not the norm. Most categories of employees out there do not get a written employment agreement. So as you look at your employment agreement, you may find that it looks a lot like an employment at will arrangement because the employer reserves the right to make changes at will, or potentially, even if it suggests that it's a multi-year contract, that they have the opportunity to terminate it at will. So look at your employment agreement as an opportunity to negotiate, and if you have leverage, if you are being sought after, there may be greater opportunities to negotiate. So what to look for? As we said, you want to investigate your potential employer as much as they investigate you. What do you know about them? Have you talked to other recently hired physicians at the medical group, or should say hospital there? Have you asked about any recent, will you ask about any recent physician departures and the reasons they left? If it's important to you, ask about family leave, disability coverage, on-call requirements, what changes are expected in the practice, how they use technology, affiliations, whether there's risk-sharing arrangements that you'll be expected to participate in. Obviously, work-life balance is very important to lots of folks. So how is that? What's the general reputation of the organization that you're considering in terms of the work-life balance? You'll want to understand what the prerequisites are to commencing practice, your medical license, your DEA registration, as we noted before, medical staff applications and privileges, managed care contracting, enrollment in Medicare and Medicaid. These are going to be basic prerequisites to practice. They're also these applications or enrollments will take time, and so it's important to understand as you're considering an employment opportunity that you understand that there can sometimes be a delay in when you might be ready to start work and when the employer will be ready for you to start work. If they can't bill for you, they are not likely going to start paying you salary until you've been credentialed and enrolled in Medicaid and Medicare. So the employment agreement can be very detailed or very general in describing what your duties are going to be. And this is, I find that the employment agreements vary by health system, by medical group, as to the level of detail that's in the agreement. It is very typical that you will see an exclusivity provision, that the employer does not expect that you will be engaging in moonlighting activities or taking on other outside activities. This is very common because the employer, first of all, wants your attention and loyalty to them. And they also recognize that to the extent that they're arranging for your malpractice insurance and you're working under their corporation or system, that your actions could be attributable to them. And so they very much want to understand what you're doing, approving what you're doing. So if you have any expectations that you want to teach, you want to do consulting, you want to take on locums work in addition to the work that you might do for your employer, those are issues that would need to be negotiated and worked out in advance. You may see, and this is very much variable on specialty, whether the contract specifically addresses hours and days of work, as well as participation in on-call arrangements, what's expected with regard, again, to your hospital privileges or managed care enrollment. There would typically be references, and again, depending upon the sophistication of the employer, expectations around medical record documentation, coding expectations, generally compliance with or adherence to codes of conduct and collaborativeness or playing well with others to ensure a comfortable work environment, a safe work environment, a professional work environment. How will you be compensated? This is an area where I'm seeing the most evolution or change. For many, many years, the approach to compensation was a combination of a base salary with a productivity or bonus payment opportunity. The base salary would be guaranteed, and then total compensation could be adjusted to reflect individual performance. Or what we're seeing now more so is a combination that still obviously considers productivity, the volume of services rendered or the relative value units of the work that you're performing, but that there is a increased emphasis on some of the quality indicators, reporting expectations, patient outcomes or other measures of value that are being built into the compensation arrangements, and this is typically reflective of the types of contracts that certain larger health systems or medical groups that are participating in accountable care organizations or other contracting arrangements where they're making promises to payers or participating in a program with the Medicare program where they're making promises around value or performance. And so those necessarily have to be reflected in employment agreements. This is, I would say, a relatively new trend over the last 3 or 4 years, and I would expect it to continue. And we'll see more of your compensation potentially tied to value or outcomes. And so I think I've probably covered this slide in terms of, the recognition that the movement is away from straight salaries to salaries plus some variable component that is based upon whether it's managing chronic conditions or keeping patients out of the emergency department or working to keep patients from being readmitted to the hospital. Oftentimes, if you're part of a larger group or part of a health system, you will get evaluated based upon how well you're coordinating the care. And hopefully there are additional supports in place within the practice settings to support the activities of the group overall. Benefits. Great variability depending upon, the size of your employer. Generally in a health system, the The employee benefits are standardized. There's not a lot of opportunity for variability. These plans are dictated, for the system itself, addressing health and life and disability insurance. Moving expenses may or may not be something that is available. Certainly, vacation schedules or paid time off, and as well as CME leave are either embedded in your contracts or may be in a summary document that defines the benefits that are going to be available to you. Generally, if it's in a separate document, there'll be a cross-reference in your employment agreement to those benefits. And with regard to many benefits, the expectation is that the employer will have the opportunity to adjust those benefits going forward on notice. When negotiating an agreement, we will typically recognize that it is the employer's discretion to adjust those benefits, but we want to be sure that if there is an adjustment, that no single physician is singled out, but rather that any change in the benefit would apply to all physicians or all professionals, depending upon who the employer might be, so that there isn't any disparate treatment or uneven treatment of similarly situated professionals. Malpractice insurance, I know this was a topic that was addressed in several questions that were received before the webinar began, and it is important to understand how insurance is issued or written. So the insurance policies, to the extent that there is an individual insurance policy that is going to be arranged for you as part of your insurance, are written on what's called a claims-made or occurrence basis. The claims-made policy will cover claims as long as the policy is in effect. And typically this policy ends when your employment ends. So some of you may have heard about the need for tail coverage. And generally speaking, if you don't purchase tail coverage, a subsequently filed claim that is related to conduct while you're employed is not going to be covered by a claims-made policy when a tail policy has not been purchased. And so if you are looking at an employment agreement and the employment agreement is silent as to whether insurance is on a claims-made or an occurrence basis, you want to ask your employer or your potential employer that if it's written on a claims-made basis, that the employer agrees to pay for the tail, or if, and this is preferable, because then you don't have to worry about whether your employer fulfills that promise to buy the tail coverage. It's preferable to ask for an occurrence policy. Now, the occurrence policy has the tail built into it, and therefore it is generally going to be more expensive for your employer to purchase. But for your own peace of mind, if your employer is amenable, and many employers already purchase insurance on an occurrence basis. They don't want to look at a big bill at the end of someone's employment and have to come up with that premium. So they will buy occurrence coverage from the start. But you very much want to address this issue and make sure that you understand how the insurance is written. And it's my opinion, my professional opinion, that the employer should be picking up the cost of the tail. It's not always the position that they will, but you should definitely be asking for it. And this really kind of, this slide really addresses, you know, the statute of limitations on claims and why is this relevant? It's relevant to point out that if you worked for an employer from 2018 to 2020 and you had a claims-made policy and there was not a tail purchased, the statute of limitations, you know, which is generally 2.5 years from the date of an incident or event that leads to a claim for malpractice. If you left your employer in 2020, you could potentially have a claim that doesn't arise or isn't filed until 2022 or even the beginning of 2023. And so you need to consider that tail coverage is going to be essential to protecting you from a claim that could you might not even know about until after you left your employment. All right, term and termination. I've spoken to many physicians who come to me and they'll say, so the employer offered me a 2-year contract or a 3-year contract, and or even it's a 1-year contract, and I say, okay, that fits within your plan. You're prepared to commit 1 year or 2 years or 3 years. And then we look at the termination provision. And the termination provision includes a reference to either party being able to terminate the agreement on 90 days notice, oftentimes without cause. So with that in mind, or sometimes it might not even say 90 days, it may say 30 days, or it may say 60 days. The consequence being that even though you think it's a multi-year contract and you're planning as if you're going to be with this employer for a year or 2 years or 3 years, it's really important not to ignore the termination provisions and to recognize that the termination provisions could very well reduce that multi-year contract to really a promise of employment for something significantly less, because they can terminate it on 60 days or 90 days notice without cause. So, so you really want to look at that. I will tell you that you know, if you both checked each other out and you've you know, done your respective due diligence, you should not be expected to allow your employer to terminate you without cause on less than 90 days notice. And ideally, it's 120 or it's 150. And the reason for that is your ability to bounce back quickly from a termination is going to be based upon how quickly you'll be able to get hospital privileges somewhere and to be re-credentialed with managed care plans, which can take as many as 90 days. And so with that in mind, if you were to lose your job on January 1, even if you found a job on January 2nd, you wouldn't necessarily be able to start with that new job until as many as 90 days later, because of how long it will take to get credentialed with health plans. And that's assuming that, you know, you are, you know, not having also to get a new medical license because you're going to go from New York to Connecticut or from New York to Florida. So you really want to make sure that you have sufficient time. That doesn't mean that an employer can't terminate you for cause unless notice or potentially no notice. But in terms of just allowing the employer to terminate you without cause, you need the time to react and have a plan to select and get in place another job. Typically, your termination provisions will as I said, address cause and no cause termination, and you see, obviously death or disability can be cause for termination, as well as misconduct, objective standards like loss of your license or loss of privileges or exclusion from Medicare. The other thing about termination provisions is you will often see some very subjective reasons why an employer may be allowed to terminate you. And in those cases, your lawyer will work with you to try to insert, reasonable standards or other provisions that try to make the basis for termination more objective than subjective. I covered this in terms of, your need to be having enough lead time to be credentialed as a new employer hospital. So I won't belabor that. As a physician newly starting out, it's probably not realistic to expect that you'll get a severance with your termination. More senior physicians who've been recruited to a position and maybe lured away from, another employer, may have more leverage to seek some severance pay and extension of benefits for terminations. This is a sample termination provision. Again, it kind of just emphasizes that you have a multi-year contract here. There may be an automatic renewal, or there may be a fixed termination date, which would require the parties to sit down and renegotiate an extension or a continuation of the arrangement. Typically built into the termination or the term provision is, notice if the parties are not going to continue, so that, again, you can plan. Ideally, you're going to have more than 60 days, but, that's going to be a process of negotiation. This is a sample termination provision. And you're going to have access to these slides, so I'm not going to go through the various potential grounds for termination, but if you have any specific questions, you can circle back with ACP, and they can get those to me. So what other contract terms might there be? So some employers will ask that you make certain representations and warranties about yourself regarding your license status, your insurability, your board certification, that you're not a party to a civil, criminal, or administrative suit or proceeding, that you're unaware of any threatened actions, that there's no other contract that you're subject to that would preclude you from entering into this contract. I have a lot of physicians who kind of skim over those things and don't realize that you need to be sure that those representations and warranties are accurate. A misrepresentation or anything that is found to be untruthful can be grounds for termination. And so you want to be sure that if it says you're board certified and you're representing your board certified, but you're not yet, that you clarify that. And if you signed a contract and that contract has a restrictive covenant provision in it, and we're going to talk about those in a minute, that you are generally, if you're entertaining employment by another employer who's in the restrictive covenant zone, you are not free to sign that contract unless you get a waiver from your existing employer. So you don't want to make a representation that you're not under any other contractual obligation that would preclude you from signing this new employment agreement. So you want to be very clear about any representations and warranties that you're being asked to include in an employment agreement. Um, medical records ownership. This is an issue that does get addressed. Most employers will assert an ownership interest or control over the medical records that you will generate in the delivery of your services, but it is important for you to preserve access to those records after termination, especially if those records might become a question in any kind of regulatory proceeding or a malpractice action, and you want to ensure that you have continued access to those records, because they are essentially an accounting of what you did, and you may need them to support a defense or a response to an inquiry. As I said, we're going to talk about non-compete and non-solicitation provisions. You will often see confidentiality and non-disclosure agreements or provisions in your contracts, and you may, again, in many cases, not be able to change much about your contract, but I say to physicians, even if you think you have no choice, and this is where you want to go to work and you're not inclined to want to negotiate provisions because you're happy with the position, it's really important to understand what you're signing. It's really because your conduct is got to adhere to or align with the provisions of your contract. So you if nothing else, need to understand what the expectations are. If your agreement says that you shall not talk about your employer's, processes or procedures, or you shall not share information about other information you might have access to in your role as an employee, you need to know that so that you don't violate that provision. Less and less am I seeing employment agreements for new physicians, including provisions about how one might become a shareholder in a professional corporation, or how one might become a member in a professional limited liability company going forward. Some of that is because more and more physicians are going to work for larger health systems, and to the extent, in New York, for example, they're not-for-profit systems, there's not an opportunity to become an owner, a shareholder, or a member. So, and even some of the larger medical groups, there's not a promise that you will necessarily become a shareholder or member in the future. But there are still some examples of that in smaller groups, mostly groups less than 10, where those kinds of provisions really are forecasting kind of the transition of the practice to the next generation of physicians. But I would not necessarily expect to see it. The other typical provision involves dispute resolution. Most contracts, recognize that either party, in trying to enforce the contract, may go into a court of law. In many cases, employers who enter into employment agreements favor arbitration. It's not necessarily a less expensive process, but it tends to favor employers. So, seek guidance from your counsel on how you want to respond to a dispute resolution process that might restrict your ability to go to court and instead require you to use arbitration. All right, so this is the big topic that we got, I think, probably the most questions about. And specifically, are there restrictive covenants in the agreements that you're looking at? Are they enforceable? We see restrictive covenants come in the form of covenants not to compete, as well as covenants not to solicit patients. Sometimes you'll see just a non-solicitation provision, you will typically see both a non-compete and a non-solicitation. I will tell you that in New York, these are generally enforceable. That is not the case in all states. This is a question of public policy in many states, and they're just not seen as enforceable as against public policy. In New York, they are enforceable if they're deemed to be reasonable as to time, scope, and distance, and they're reasonably necessary to protect the employer's interest. The burden is on the party seeking to enforce the restrictive covenant to bring an action for injunctive relief and damages, meaning that if you have a restrictive covenant in your contract, that if you were to be viewed as in violation of that, the employer needs to bring an action to either recover damages or to prevent you from continuing to violate the covenant. That may sound good because the burden's on the employer. The problem is we've and our firm have enforced restrictive covenants because employers want to set the precedent that they will take the action to enforce them, and to the extent that they have succeeded, they are entitled to damages, which is typically the forfeiture of any salary that you've earned during the period of the violation of the restrictive covenant. So it's very important to focus on these provisions when you sign your contract. And I will say, I say to physicians all the time, what's your exit strategy? If this doesn't work out, what are you going to do? Where would you go? And could you stay out of this area for a year or 2 years, which is the typical time frame that we see covenants that have been enforced. It's 1 or 2 years. So you want to, this is a significant contractual provision, and you want to approach the arrangement thinking about, okay, if it doesn't work out because I don't like it or they get rid of me, what are my options? What are my choices? Now, some courts have refused to enforce them where an employer has acted in bad faith. But that is, I would recommend that you don't want to have to litigate this provision. You want to try up front to figure out, what are your alternatives. From the employer's perspective, they're going to say they've made a substantial investment in you, whether it's training, it's introduction to patients, it's assistance in building the practice, it's the physical locations of these practices to the extent that, they do the advertising, they take on the overhead responsibility. So they think, this business is something that, they're allowing you to partake in, not something that you have a right to take away from them if you were to leave. You, on the other hand, need to be able to bounce back or have the ability to kind of continue to practice, especially when you feel like you've built a reputation, you become a member of your community, you have a home, your kids are in school, really what's your choice? So again, think about your exit strategy. When I approach these covenants from the employee perspective, we want to negotiate the time frame as short as possible, so a year. You want to narrow what it means to compete. If your employer is, you're engaged in a primary care practice, and the employer has 50 practice sites or 35 practice sites, but you're going to spend all of your time at, this one practice site, or you're going to split yourself between 2 practice sites, narrow the geography, so that, you're going to be precluded from practicing in the area that is where most of the patients that you are seeing are coming from. And so we have actually used zip codes based upon, the prevalence of the zip codes from which patients are originating to narrow a restrictive covenant, but also that you're not going to be precluded from taking a medical directorship position with a managed care plan, because how does that compete with your employer who wanted you, as a primary care provider, delivering services directly to patients? So you want to look at the geography, you want to look at the length of time that the restrictive covenant will be in place. You'll want to look at what are the kinds of things that you could do as an alternative to whatever you've been engaged to do for that employer. The other things is, we will often negotiate if the employer does have a termination without clause provision, that if they exercise that termination without clause, that the restrictive covenant doesn't apply. That, they're essentially displacing you without clause. And so in doing so, the trade-off to that should be that you should not have to totally disrupt your life, and you should have the opportunity to resume practice with somebody else in the restrictive covenant zone. The other thing that I will say about restrictive covenants is if you find yourself in a current employment agreement and you're subject to a restrictive covenant, my experience has been that depending upon the circumstances surrounding your potential departure, and if it's generally a amicable departure or separation, it is not impossible. We've certainly had plenty of instances where the employer has voluntarily waived the restrictive covenant to allow the employee to move on. And so you should consider whether that is a possibility as well. And I find that, oftentimes there's, in the end, no harm in asking for that waiver. Something you'll coordinate with your counsel, but in the end, it may very well be that the employer, even though they put it in the agreement from the start, that they may be willing to bend on that and give you a release or a waiver to allow you to make a transition. All right, we talked briefly about medical records. We're coming up on about 45 minutes. We're going to leave some time for questions. So if you want to ask any questions at this point, feel free to put them in. Otherwise, we're going to turn to the questions that we received in advance of the presentation. But as I said, your employment agreement will typically address medical records. They'll address your expectations around certain professional responsibilities about documentation. It is your professional responsibility to maintain accurate medical records for everyone that you treat. That includes your family members, if you or your neighbors or others, if you are going to be writing a prescription for anyone, if you are going to be prescribing any treatment for someone, you need to be sure that you are generating medical records that capture that activity. It's extremely important to do so. There have been many instances where physicians have kind of ignored that or acted more informally and then have been called on the carpet for failure to maintain their professional records. They're important for your license, they're important for billing purposes, they're important to defend against malpractice actions. There's lots of reasons why one should be complete and accurate in their documentation. And I'll just put a footnote here for a second. In this world of electronic health records, there is increased scrutiny that is placed on medical record documentation, which appears to really be just a cut and paste job of prior encounters, and we are seeing more and more inquiries where, whether it's a payer who's questioning the level of service designation or in a malpractice context, questions from plaintiff's counsel around whether the record is actually an accurate reflection of the service that was rendered, because the medical record itself appears to be multiple services or multiple dates of service with a cut and paste of the prior visit. And so it's extremely important in your medical records documentation that you are able to distinguish the services that you've rendered from one to the other. And although record systems can provide great shortcuts and assist in maintaining accurate documentation, the systems can also be abused and then lead to questions about the integrity of the record. We have had certain clients who've actually adjusted their record systems to prevent that kind of cut and paste feature. Many others have retained it, but put rules around that to remind physicians not to take those kinds of shortcuts because it can have implications and call into question the integrity of the records going forward. Again, with medical records, there's a duty to retain. This is something that's generally going to fall on your employer, but it's something you should all be aware of. Generally, under state law, it's a 6-year requirement, unless we're talking about records of minors or obstetrical records. And in addition to the state standards on records retention, there are federal rules that impose longer periods of time. 10 years is a typical requirement built into agreements involving Medicare managed care plans. And we talked about negotiating access after termination of your employment so that you can obtain the records if needed to respond to legal claims or investigations. So that's the end of the formal presentation. We will entertain some questions which are in the queue, and Karen, you're going to tee me up for those?
I sure will. Thank you, Lori. That was very informative. As Lori mentioned earlier, please feel free to write your questions in the dialog box on the right-hand side of your screen. We have about 10 minutes for your questions, and we still have the ones that were written in. One of the questions that came in is, if I am working with a locum tenens for a 2-month position and the malpractice insurance is claims-based, covering only up to several months after the position is over, do you recommend purchasing tail? And for how long would you recommend purchasing the tail?
So if you are working in a locums arrangement and the insurance is claims made, I would suggest that you go back and request that the company arrange for the tail coverage. If you're not the policyholder, it's very difficult to obtain a tail policy from another insurer to insure your prior activities. It's generally called a nose policy, and they're very expensive. So if you're accepting a locums position, I would be very wary of accepting coverage that is issued on a claims-made basis, because I'm not sure you will be able to buy a tail policy. If the locums company has put the policy in your name and has ensured that you'll be able to buy the tail, then you'll want tail coverage. There's no length of time. The tail coverage will essentially be a premium that will cover everything that might arise or might come to be learned to have arisen from the period of time that you were working. And so it's not a question of having it for a period of time. The coverage is there in the event that anything arises.
Okay, we are getting several questions in the queue. After termination, are you entitled to have access to your performance data, especially financial data, to verify that your leadership did not fail to compensate you for productivity bonuses?
So generally speaking, if your compensation is based upon RVUs, and which is not uncommon, then there should be the employment agreement should address access to the performance data so that you can verify, not just at the end of your employment, but during your employment, that they are capturing your services. And in my experience in some systems, is that you will get those quarterly reports because they want you to know where you're standing. If that's not your experience with your employer right now, I would certainly be asking for access to that data, because it's first of all, it helps you to be aware of your productivity, especially if you've set personal goals for yourself in terms of what your productivity bonus may be. So you should be getting regular access to that data, and the expectation would be that if you're entitled to a payment of a bonus after termination, that you'd have access to the data for that purpose as well. And I'll pause for a second and just say that with regard to a productivity bonus or a performance bonus, you should look carefully at your agreement to determine whether the contract specifically states that the payment of the bonus is premised on your being an employee at the time the bonus is calculated. And there is oftentimes language that I've seen in a contract that will not guarantee that you will get the bonus if you have left employment before the bonus has been calculated. And so oftentimes with an RVU count, you will not, or if your bonus is based upon gross collections, you will not know those numbers for possibly 60 or 90 days after the measurement period, the calendar year, because you will have the claims processing system that will have to catch up and calculate that final quarter and come up with an annual number. So oftentimes the contract can provide that the bonus will not be payable unless you're employed at the time it would otherwise be paid.
Okay. Thanks, Lori. The next question is, can you clarify, if employer terminates you, can they enforce the restrictive covenant?
This is going to be a question that's answered by the contract. The fact that you were terminated is not necessarily going to negate the applicability of the restrictive covenant. As I mentioned during the talk, one of the negotiating strategies around restrictive covenants is to insert an exception to the restrictive covenant in those cases where the employer has terminated without cause. It is very unusual to have a restrictive covenant that would be waived or inapplicable because they terminated you for cause. And so, again, this is going to be dictated by the contract. But the enforceability of the restrictive covenant is not dependent upon how the, who terminated the arrangement, unless it's specifically addressed in the contract.
All right, the next question. My wife will join on a J1 waivership, hospitalist or PCP position from July 2019. What are the important contract details that should be addressed pertaining to the employment to secure 3 years of her J1 waivership?
So she's got a waiver for her J1 right now. I think that's what I'm understanding from this. So typically a J1 visa would require someone to return to their home country, and they would not be allowed to stay. There are programs that allow a limited number of J1 visa holders to stay in the United States. If your wife is one of those candidates who is going to be eligible for a waiver, her contract probably is going to look a little differently. Generally, the contract will be something that gets presented here in New York. It would go to the New York State Department of Health, and they would generally restrict some of the, or opine on some of these provisions because the expectation is, unless your wife does something seriously wrong, that there's a 3-year commitment or there's a multi-year commitment to employment. One of the things that you might want to address in the contract is financial assistance in obtaining permanent resident status or the green card, because I'm assuming she'll move to an H-1B visa. And the question is, if the plan is to stay here long term. I'm not an immigration attorney, but have worked with immigration attorneys. You'll want to potentially address assistance in getting permanent resident status.
Great. We're coming down to the last question and the last minute of the presentation. Can you publish data from a cohort of patients with a mix of current and prior institutions?
This raises a number of questions probably beyond this presentation. I will say to you, when you talk about a cohort of patients, it's not clear to me whether you're talking about information that would be truly considered de-identified information, so it's not clear whether you're talking about PHI or not. That would be subject to confidentiality rules. I will also say to you that you are probably, as an employee, without specific authority or permission from your employer, you're probably not expected to utilize patient data or even de-identified data for your own use. And so I would be mindful of any limitations around confidentiality and limitations on your use of even de-identified patient data without seeking specific permission from your employer.
Thank you, Lori. That concludes our questions for this afternoon. Once again, I'd like to thank Lori very much for her wonderful webinar this afternoon. Also, please note that we will have the recorded version on the chapter's website early next week, and I will also be sending all attendings who are participating today a handout of the slides. This concludes the webinar. Thanks, everybody.
Thank you very much.
All right, have a great afternoon. Okay, I can do an hour, please.